everybody. Welcome back. Welcome to my recap of day 3 of the State versus Richard Allen. We had primarily motions in limine today. Once again, I'll give you the bottom line. The composite motion and the motion on excluding Dr. Tobin, these were taken under advisement. Judge Gull has not ruled on them. She did make some comments that may signal where she's going, and we'll talk about that when we get to it. On the motion for the state to have 2 representatives assist them at the table that would then not be subject to the witness exclusion order, Judge Gull granted that over the defense objection. On the defense's motion to preclude the state's prison guards, lay witnesses, basically just, people without any kind of special training or expertise. The defense wants to preclude those witnesses from being able to testify that in their opinion, Richard Allen was faking mental illness. And the state takes the position that these are skilled witnesses, that they have training and experience that enables them to form these types of perceptions. And the bottom line on this one is that it's going to be taken individually on a witness by witness basis. The state will have to lay a foundation to establish how the witness would know that. But if they are able to do that to Judge Gull's satisfaction, then it seems that that is going to be allowed. On the state's motion to God, I'm drawing a blank now. It's been a little bit of a long day, guys. Flip through my notes here. Oh, of course, the iPass settlement. The state wanted to exclude any reference to the civil settlement that arose from a case from 2012, ultimately settled and resulted in a settlement that essentially set the standards for treatment of prisoners in the Department of Corrections facilities. And that motion was granted. So, the composites under advisement, the Tobin under advisement, the lay witnesses individually. We'll take it one by one. iPass out. Not going to be allowed to mention that. And state gets their extra representative there with them in the courtroom. The jury was also sworn today, and so we got a little bit of information about that and kind of what was going on with the whole, miscount and so forth. So first off, I will tell you guys, I gotta fess up here. Wasn't here for the whole day. I wasn't able to make it for the whole thing. I got there about 10 o'clock. And unfortunately, I don't even have a good story. Odinus ran me off the road. No, nothing like that. My phone charger fell out of the wall last night. Phone died, alarm didn't go off. Oh, so rookie move. Rookie move, wake up, and like instantly know something's wrong because it's light outside. You guys, that feeling, and like you wake up in an adrenaline flood. Not the best morning ever. But so I did book it over there, and fortunately Lawyer Lee, who was there, who is awesome, by the way. If you're not following her, follow her. She is doing a fantastic job keeping up on this case as well. She was kind enough to share me her notes and fill me in on what happened during the parts that I wasn't able to be there. So thank you so much to Lawyer Lee. You are awesome, and I really appreciate it a ton. It also turned out that after Judge Gull tells us that the court schedule is going to be 9 a.m. daily to 5 or 6 or whenever they feel like getting done. Today, apparently, she decided to start at 8:30 without telling anybody. Just just kind of part of the chaos that we're coming to expect with this particular case. So when they started the day off, they started with the composite motion, and I really am I'm angry that I missed this. I'm mad at myself because they had a witness testify. The guy who prepared the sketch testify. So I'm going to rely on lawyer Lee's notes here to kind of describe what he talked about. His name was Thomas Plants. He's a retired special agent with the FBI. He was law enforcement with Indiana State Police beginning in 1995. And then in 2004, he started with the FBI as a special agent and a forensic artist. He was the first FBI agent who was qualified to do forensic art. So he described a little bit about what that means, how that process works. And, not surprise, surprise, not necessarily like you see on TV. And so what he described it is more of a culmination of a very extended interview, what he called a cognitive interview of the witness. And he's exploring a variety of things in this interview process. So first off, the process itself is very open-ended. Structurally, it's designed to basically have the witness do like a memory dump, everything that they recall. And then once they have kind of finished recounting everything, then they would be more comfortable going back and trying to fill in some details around the edges, follow up on certain things, and so forth. But basically a process that's intended to not, taint the witness's recollection. So we talked a lot about the process of memory, the encoding, the storage, and then the recall, and different things, different phenomena can affect each stage of the memory process. So particularly with the encoding, they're looking at things like, what was your ability to observe? Were you looking at this person very long? How was the lighting? Just things along those lines that go to your ability to really capture some type of recollection in the first place. And then things like stress can affect recall. He according to the notes, I wish I would have loved to have heard some of what he had to say about these details, because he talked about things like environmental factors and background can really affect the ability to, encode and store and recall memories. And so they are interested in things like, were you a victim versus were you just somebody who happened to be in the area, because you have different motivations, different, just, if it's a random person, it's less likely to catch your attention. You're less likely to be interested in capturing details. You're going to be probably more vague. On the other hand, if you're a victim, if you have direct consequences, direct impact from a dealing with somebody, then you're probably more interested in recalling some of those details. Part of the counterpoint to that, though, is that particularly with violent crime, I don't know if he discussed this. This is just something that I know that's come out from prior work that I've done on cases, that there can be a problem with focus. Like, so for example, somebody approaches you and they have a gun. Probably 99.9% of us are going to focus on that gun. You're going to have tunnel vision because that's the threat. And so the tendency is going to be to focus on the threat. And then because of that, the details of, height, skin color, eye color, hair color, like somebody who's being threatened by a person with a firearm, you may not even look that person in the eye. You may not even know what their eye color is because you're going to be too scared, too intimidated to look at that person in a, potentially what you would be concerned might be a confrontational kind of manner. So all of these things affect the witness's ability to be able to have a memory that they can then draw on in order to make a sketch. So the sketch itself comes at the very end of the process. They go through the interview process first and then sit down and try to reduce that description that the witness has made into something visual. And so that part of it does sound like it's more like TV. You know, they sit side by side, they work on it together. If they have uncertainty about, a particular feature like the nose shape or something like that, or difficulty describing it, then they just kind of try to work through that and try to see if they're able to flesh that out. If the person doesn't have a sufficient memory, or just ability to recall sufficient details, then they probably won't make a sketch. They won't try to make that effort. So it seems like it does require a pretty extensive recollection, like a pretty clear memory for this part of the process to even go forward. He gave some interesting information about being able to estimate age. Like estimating age apparently is quite difficult. Which I guess, when I think about it, it kind of makes sense. Like if I see somebody right now who's 50s, 60s, 70s, I can probably guess, what decade they're in. Like, I don't know. But if I look at the youngins now, like they just all look so young. I look at like the pro athletes, they look like babies. So for me personally, I would have a much harder time, I think, estimating the age of somebody who's quite a bit younger than me, than somebody who is a fair amount older. But he brought that up just because it's something they have to be a little bit careful with, because say you're interviewing a young person and they're like, oh yeah, the guy was old. Well, what does that mean? To a teenager, an old person, I'm probably an old person, to a teenager. Do you mean, somebody 40s? Like, so they would have to drill in on details like, well, did they have wrinkles? Did they have gray hair? Things along those lines to try to fill in those details. He did testify that the sketches are not intended to be used to identify somebody in court, that is not the purpose of doing that sketch. And so that really got to the heart of what the state was arguing. So when we talked last time on Tuesday, I had not yet seen this motion, and I do have it now. I'm going to go ahead. It's going to take me a second here, but I'm going to go ahead and pull it up so that we can look through it. Okay, here is our image. Let me get it bigger. All right, how does that look? That is more visible. Good. So this is the motion in limine. Comes now the state of Indiana respectfully requests the court enter an order prohibiting the admission or reference to composite sketches. Okay, so not just exclude the sketches, but the very fact that they were made wants to be excluded. Prepared by any sketch artist for the investigation of the murders of Abigail Williams and Liberty German for the reason that a composite sketch is not relevant, admission would result in undue prejudice, confuse, or mislead the jury, or is impermissible hearsay. That's what we talked about on Tuesday. And the witness who participated in the preparation of the composite sketches will not be presented by the state for the purpose of in-court identification of the defendant. Well, that's interesting, isn't it? Isn't that interesting? Because are we to believe the state didn't ask them if they could identify Mr. Allen as a suspect? That would be quite an oversight had they not done so. And if they had not done so, I would tend to think the defense has done so. And so I think we can conclude from this, they're not identifying Mr. Allen as the person that they saw as the suspect. Take from that what you will. In support of this motion, the state would show the court the following. The composite sketches prepared were intended as an investigative tool to generate leads to identify a suspect, and in fact, these sketches were not related to the identification of Richard Allen as a suspect. Therefore, the sketches would not be relevant under Indiana Evidence Rule 401. This is just a strange argument to me. Yes, they were sketches of the suspect, of the person that they believed committed the crime. They believe Richard Allen committed the crime. It seems to me, therefore, they are highly relevant to the identification of Richard Allen as the perpetrator. This is a strange argument to me. It goes on, the witnesses who assisted in the preparation of the composite sketches of the bridge guy. See, this is real important, right? Sketches are bridge guy. Rick Allen is bridge guy. Therefore, the sketches should look like Rick. They should look like Mr. Allen. The witnesses would testify that they did not see the person depicted in their sketch for a sufficient length of time to allow them to positively identify the defendant. Therefore, again, under Indiana Rule of Evidence 401, the composite sketches are not relevant evidence. The inability to identify him despite having created a sketch of a person that they saw long enough to recall clearly enough to produce a sketch, that seems to be pretty relevant to me. So this relevance argument is, to me, it's strange. It honestly did not even cross my mind that they would make that argument, because of course it's relevant. Of course it's relevant. Good Lord. That if the court were to consider the composite sketches to be relevant, the probative value is substantially outweighed by the unfair prejudice confusing the issues and misleading the jury, and therefore should be excluded. A composite sketch reflects the police artist's interpretation of someone else's description based on the artist's synthesis of an infinite variety of facial features and configurations. Creating a composite sketch carries the potential suggestiveness of having a police artist interpret and possibly influence the perceptions of the witness. Well, this is why they took the testimony to talk about that process and how they go through the interview, the significant interview, ahead of time for the purpose of not being suggestive to the witness, to get that brain dump, everything that they can possibly recall. And then based on that, determine, are we even going to be able to make a sketch at all? So, yeah, substantially outweighed by unfair. What's the unfair prejudice? You know, they might think that the sketches don't look like Mr. Allen. Yeah. That the composite sketches would be hearsay or double hearsay under Indiana Rules of Evidence 803, in that the sketch is an out-of-court statement and a subjective rendering by one person using the subjective description by another person/witness, and does not fall within a recognized exception. This is the best argument they got, okay, my opinion. This is the best argument they got. It's hearsay. It's certainly hearsay to the extent that it is, it's based on what the witness told them, the description the witness gave. It's based on that. So that yes, is an out-of-court statement offered for the truth of what it says, that the person that witness saw looked like this. So it is hearsay. I think that is a pretty good argument. Whether it falls under an exception is a much more close question. It is the state's belief that the defense intends to use composite sketches from the investigation as a demonstrative evidence and for impeachment purposes. That the witnesses who participated in the preparation of composite sketches are not being called to provide in-court identification of the accused. Furthermore, no composite sketch was instrumental in identifying Richard Allen as a suspect. So what the state is doing here is they're narrowing down this issue of identification very narrowly. They're saying basically only if we identify Richard Allen does identification matter. Well, we're identifying bridge guy, and the state has put bridge guy at issue. The state made it clear in their opening statement that one of the three things this case is about is bridge guy. So the identity of bridge guy is pretty critical. And if the sketches are supposed to be bridge guy, and Richard Allen is supposed to be bridge guy, then I don't see how you get past this being an identification issue. So the fact that the witnesses are not being called to provide in-court identification of the accused, okay, the state doesn't want to call them. Well, the defense can call them. The defense can call them. And the defense can ask them to do an in-court identification if they can. The defense can do that. And I did check, too, in Indiana, under the rules, the defense can impeach their own witness. So if they don't remember or they say something different than before, the defense can bring up prior inconsistent statements, such as, for example, the type of description that would allow a composite sketch to be created. So that doesn't necessarily bring the composite sketch itself in, but remember, this motion isn't just exclude the composite sketch, it's exclude any reference to it. So imagine one of these witnesses gets on the stand and is like, yeah, I don't know what I saw. I don't have anywhere. I never talked to police. I never said anything. Under the plain language of this motion and the ruling, they don't get to say, oh, but you made a composite sketch. You gave a description at the time. Police made a composite sketch based off of your description. They don't get to do that. Yeah, this is very, very, very alarming. Oops, didn't mean to do that yet. Let me zoom back in here. The prejudicial effect of composite sketches far outweighs the probative value for in-court identification of the accused and would likewise be inappropriately used to impeach a witness who is not presented before the jury to provide in-court identification of the accused. This is the state inferring, I think, what the defense is doing. If they're an eyewitness and they get up on the stand and they say, the man I saw was not Richard Allen, under the state's theory, that's inadmissible, because they're not identifying Mr. Allen. The state is reading the rules so narrowly here that only an identification of Mr. Allen is going to be relevant and probative and helpful and not unduly prejudicial to the jury. That if somebody says bridge guy was somebody else, that seems to be irrelevant under the state's argument. This is wild. This is wild. Indiana courts have not addressed this issue or use of composite sketches. Indiana courts have excluded composite sketches that resulted from the use of a victim/witness hypnosis. Other Indiana cases discuss or mention the existence of a composite sketch in the course of an investigation leading to probable cause to arrest, but no analysis of their use as evidence to impeach witness testimony. Wherefore, they want to order the defendant, his counsel, and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to composite sketches without first obtaining permission of the court outside the presence and hearing of the jury, and to further order said persons to make no reference to the fact that this motion has been filed and granted. So that's normal. You don't get to bring up the fact that the court doesn't let you do something. But yeah, no reference whatsoever, directly or indirectly, to composite sketches. Now, let me tell you another reason why this is a problem. The composite sketches were a key part of this investigation. They were what the police were using to try to generate leads, to try to get information. They put these things out in public. They asked the public for assistance in trying to identify the person who was depicted on these sketches. And that's part of how this process unfolded. So the investigation is subject to impeachment in a criminal trial. You get to argue the police did a bad job. The police didn't pursue leads. The police handled things improperly. So this is also limiting their ability to challenge the investigation. I mean, this is honestly, this is wild to me. Absolutely wild. So when I got into court, they were doing the argument. They were into the argument on the composite sketches. And so Ms. Diener was doing the argument on this one. This was the first time I had seen anybody besides Mr. McClelland from the prosecutor's side, do anything official in court. And so just basically repeating the same argument that just because it was just used to generate leads, so they're irrelevant, they're double hearsay, and there was some issue from one of the witnesses had testified that the drawing was a 10 out of 10 match to the person that she saw on the bridge. So she ratified this drawing. She accepted it. She incorporated it. She validated it as a fair and accurate reflection of the person that she described. And according to the state, well, that might have meant something different than what she said. So Ms. Auger argued for the defense, and she argued there is a hearsay exception, that the hearsay exception is Rule 801 D1C, which is an exception for statements of identification. So I want to go ahead and pull that up. This is going to take me just half a second to get it on the screen. Okay. Let me see if I can share that. This might not be so good in terms of our readability because it is... Okay, here we go. Can we see that okay? Okay. Statements that are not hearsay. D1C, identification of a person shortly after perceiving the person. Shortly after perceiving the person. Bridge guy. This is an identification of bridge guy shortly after seeing bridge guy. This should be an exception. This should be an exception. She testified that the sketch by about Betsy Blair was 3 days after. Sarah, I didn't catch the last name, but was the other witness who helped prepare a sketch. It was 4 months after. And that, yes, of course, the sketch wasn't used to ID Mr. Allen because it looks nothing like him. Ms. Auger raised the issue of it relating to the Fifth Amendment right to cross-examine on identification. I didn't fully follow this argument because it seems clear the state is indicating they are not calling these people and they're not calling them for identification, period. So Mr. Allen can call them, and I expect he probably will, to get their description and to, confirm that I would assume they don't think it looks much like Mr. Allen. Certainly the young man doesn't look much like Mr. Allen at all. So they wouldn't be cross-examining those witnesses. It wouldn't implicate the right to cross-examination unless there's something else going on there with identification that I don't know about. I don't really see this as a cross-examination issue, but she says it's absolutely relevant, and I certainly agree with that. It's absolutely relevant. It's absolutely relevant. These are the identifications of bridge guy. The state says Mr. Allen is bridge guy. I don't know how you get around that. So, like I said, Judge Goal, I keep wanting to call her Judge Bev. I know I did it on Tuesday. I'm going to try real hard not to do it again, but please excuse me if I do. Let me stop sharing that. She said she's going to take it under advisement because she needs to go and look at the case law. But she said, I'm struggling with how it's recognition. It relates to recognition, but not identification, and how it's relevant as an investigative tool. So she has tipped her hand that she is leaning in favor of the state. She's adopting their narrow interpretation that if the witness doesn't recognize, or the witness's ability to recognize Mr. Allen is something different than the witness's identification of Mr. Allen as the suspect or not the suspect. To me, this is not a struggle. This is like you have to be kind of trying to not get it, It's Bridge Guy. It's really not hard to get. But she said she will rule tomorrow before opening. So that will give them guidance on whether they will be able to mention, you know, these composites or anything like that. They did, so a number of exhibits were offered into evidence today, including Ms. Blair's deposition. That's Betsy Blair. She was the one that did the sketch, prepared the sketch 3 days after. So those are now in public record. However, there have been some issues with being able to get access to exhibits. I have seen that media requested access to various exhibits. The pretrial hearing that was held back in August on the third-party culprit defense and resulted in that being excluded. The media had requested access to view those exhibits. Exhibits are indisputably public records. There's absolutely no question that the public is entitled to see them. But Judge Gold doesn't want to, and so she had initially refused the request to be able to view them. She then subsequently backpedaled on viewing the exhibits, and there was an order issued, I believe this morning. It might have been late yesterday, but I just saw it this morning. So the media was going to be allowed to review those exhibits briefly in Allen County, up there in Fort Wayne. They were going to be able to review those exhibits. And then as far as the trial exhibits goes, her order says the media will get 15 minutes at the end of each day to be able to review the trial exhibits from that day. That's the public right of access that she's bestowing on us in her benevolence. Pardon me for getting a little bit sarcastic here, but I gotta tell you, I really haven't seen anything like this, Judge. I really haven't. I mean, it's a little bit mind-blowing to me because the rules on this stuff are real crystal clear. The audio recordings, for example, of the trial, of the proceedings, crystal clear. These are public records. The public is entitled to them under the law. But the law doesn't seem to have a whole lot of influence on her decision-making process. It's really wild. She's not even trying to hide her disdain for the defense. There's a moment, I'll describe it when I get to it, but where it's just the sarcasm is dripping. She's disparaging of their arguments. I mean, it is really, really something else. So anyway, I mentioned that because Ms. Blair's deposition is now in evidence. It's an exhibit. It should be available to the public to be able to go and read and see exactly what Ms. Blair said about what she saw in the process of creating the composite and all of that. But are we going to be able to see that? Yeah, color me skeptical that that's going to be allowed. It's crazy. They had a quick little kind of side. They took a little left-hand turn to talk a little bit about logistics because Judge Gold wanted to mention about digital exhibits and how if the jury is back in the jury room and they want to look at the exhibits, she can't give them a thumb drive. They don't have anything to be able to view it. And so she was basically telling the parties they should basically present all of their evidence in physical form, so photos and things like that. So Mr. Rozzi stands up and of course is like, well, what about video? Can't really do that with video, can you? And so Judge Gohl said that they would either need to provide a medium to view it, so give the jury a laptop or a computer or something, or they would have to, everyone would have to be present if the jury wants to view it, because they have the right to do that. They would bring them back into the courtroom in the presence of the parties, play it for them. And so then there was an argument about whether each individual piece of digital evidence needs to be on like a separate thumb drive or a separate disk or whatever. And the state is of the position that, yes, they all need to be on a separate one. And it does, you know, make some sense because, for example, if you have 20 exhibits in your thumb drive, and you only admit 5 of them, what happens to the rest? Like, do you go in and just delete them? It doesn't make a very good record when it comes to just sort of the integrity of this particular piece of evidence. Once it's admitted, you're not supposed to mess with it. So I will say digital evidence, it's not new. It's not new, but in court time, it's still brand new, and it causes all kinds of issues. I mean, this is something I deal with in my appellate practice at length, trying to get copies of these things, trying to get them transmitted up. Yeah, what you get is real all over the place, and so. The defense is saying, well, but if I have multiple items on a single thumb drive, the judge is concerned about, well, how will the bailiff even know what they want to see if there's a whole bunch of things on it and so forth. Mr. Rozzi's like, well, we can identify them very clearly in the thumb drive as to what they are. So, didn't really get a clear resolution direction on where that's going to go, other than both the state and the defense said we would waive our right to be present in the courtroom. If the jury wants to view something, they can bring them back out, play it for them, and we don't have to wait for everybody else to get back there. The defense then advised that they were withdrawing their motion for a jury view of the scene. They did not specify why they were withdrawing this motion. So no clear reason as to why that decision was made. No insight for you on that one. They moved on to the motion to deal with the state's witnesses, the people that they want excluded from the witness exclusion rule. So normally if you're a witness for a party, you don't get to be in the courtroom, because if you sit and listen to everything that happens before you get on the stand, it gives you the opportunity to tailor your testimony based on what everybody before you had to say. So the state argues that the particular rule issue has different bases for exceptions for witnesses to sit in. So one is a designated representative, just kind of whoever the prosecuting attorney wants to designate as their representative, they can have sit there in court, and in spite of the exclusion order. And then Another exception was somebody who is essential to a party's presentation of the case. The state could have argued potentially that they were designating one and the other one was essential, that they were under different exceptions to the rule. But they didn't do that. They said that both of them fall under that essential presentation of the case exception. And so the one guy who works for the prosecutor's office, I believe his name is Mullen, he's been keeping track of the evidence and the discovery. He's the logistics guy. He knows where to find all the stuff. It's all organized, knows how to get it on the video players and things like that in court. The other guy, Mr. Holman, is the lead investigator, so he oversaw the interviews, the investigation, and so forth. He's the guy with the 10,000-foot view of the case, and is typically the person that you would expect to see, at least that I would expect to see, in that position of being accepted from the exclusion order. And the idea is just they have the most knowledge about the case, and so they need to be there in case the prosecutor forgets something or needs help remembering or something like that. So they argued, they had some case law. Mr. McLeland had some case law that he brought up where he argued more than one was allowed as essential because of the length and complexity of the case, and they were heavily involved and they had different roles, and that in this particular case we had even more exhibits and witnesses and a longer investigation, and we're going to have a longer trial than we did in that prior precedent. So according to Mr. Razi, the issue that they are primarily concerned about is that both of these witnesses, Mullen and Holman, were involved in interviewing the Department of Corrections witnesses who purport, they claim to have heard statements from Mr. Allen, to have observed behaviors by Mr. Allen, and so forth. And so for them to listen to each other's testimony is the problem, because it impairs his ability to be able to impeach them if there are differences of recollection or something like that between them. So the state, kind of, again, deliberately fails, and this is my read, of course, but they didn't get the point. To me, it seems like it's a kind of a deliberate not getting the point. Like it's pretty easy to understand. But he's saying, the cops can't testify about the credibility of witnesses anyway. So that's not what he was talking about. He's not talking about, Mr. Razi wasn't talking about asking Mr. Mullen, Mr. Holman to comment on the credibility of the witnesses. He's talking about the credibility of Mr. Mullen and Mr. Holman, and how the inability to keep their testimony separate from each other has the potential to relate to their credibility. Do they tell the same story? And the ability to use one to impeach the other. So the judge said, yes, both can. It's fine. Going to be over the defense objection. Granted that motion by the state. We then moved on to the motion in limine regarding the state's witnesses, the prison guards, inmates, and law enforcement officers who interviewed people at those facilities. And they used what Mr. Razi described as a template for the interview. Who are you? What was your connection with Mr. Allen? How much time did you spend observing him? What did he say or do? How was he acting? And what is your opinion about whether his actions were genuine? That this would be prefaced with questions about, do you have a background in psychology? Things like that. And no, they don't. But they're ultimately getting at opinions on, do you think he was faking? Do you think he was faking? This is a real close line to, is he telling the truth, right? Is he faking mental illness? So Mr. Razi argues that the witnesses don't have the experience to be able to offer this type of opinion. Indiana has this very strange exception to the ordinary rule that if you're a lay witness, you don't get to testify about your opinion. You don't get to testify about your opinion. You get to testify about what you observed, and you get to testify about inferences that are the kind of ordinary, routine, everyday inferences that people can make by just going through life. So, for example, I'm a lay person. I'm driving down the street. I see somebody. That person looks drunk. It doesn't take any special expertise to be able to identify somebody as drunk. It just takes life experience, having seen some drunk people. Now, a 5-year-old kid probably isn't going to be able to identify a drunk person. They might just, think that person is acting weird, or maybe they're crazy or something like that. But somebody who is older and has more experience, you can tell this person's drunk. You're allowed to testify to that type of opinion. And so to testify to something more extensive, you have to be an expert. You have to have the type of training, knowledge, experience that specifically qualifies you to give that type of opinion. And so mental health typically falls pretty squarely within this type of expertise, right? If you're going to offer an opinion about somebody's mental health, you need to not be a couch psychiatrist. You need to be a real one. So Mr. Razi argued none of them have ever been incarcerated under these conditions, so they don't have any kind of firsthand knowledge, and obviously they don't have training or expertise as psychologists or psychiatrists. Now, Indiana has this strange exception to this prohibition on lay opinion testimony for skilled witnesses. Skilled witnesses. What does that mean? Well, I looked up the case law because it's weird. A skilled witness is a person who possesses specialized knowledge short of that necessary to be declared an expert under Indiana Evidence Rule 702, but beyond that possessed by an ordinary juror. I honestly really don't know what that's supposed to mean. So the case law that I looked at to kind of flesh this out and get the flavor of what the heck is a skilled witness. This was arising from a case where a police officer was testifying about drug culture, basically. This is very, very common in drug cases. You'll get cops to testify about like what's a user quantity, talk about like the slang, talk about the different paraphernalia and things like that, you know, yeah, if you don't use heroin, you probably don't know how much is a normal amount of heroin to have and how much do you pay for it and things like that. In my state, that's expert testimony. That's proffered as expert testimony. And the police officers who have gone through the trainings and have done this type of work and they're on the drug task force and they've done, you know, 50,000 busts and they've interviewed all kinds of addicts and dealers and so forth. They're experts. They're qualified on the basis of their training experience to be able to offer that type of opinion. I take issue with it for a lot of other reasons, as I'm sure you can imagine, but in terms of expertise, that's how we handle it in Washington. Apparently in Indiana, they decided to not make cops experts, but to create this sort of very nebulous subcategory of skilled witnesses, which to me just kind of seems to be an end run around the prohibition. It's just an end run around prohibiting lay witnesses from being able to offer their opinions. So I don't get it, honestly. This distinction is not real crystal clear to me exactly where that line is drawn. So Mr. Razi went on to argue that the state of somebody's mental health, it requires expertise. Most of the witnesses acknowledged they didn't have that background. A couple of them said they took a DOC training module on mental health issues that was, he described it as similar to first responder training. So it would be things like how to recognize certain symptoms and like how to calm somebody down until, you know, they can be secured or, you know, somebody else can arrive to deal with the situation. He argued under Rule 704 that this is essentially eliciting testimony about credibility, about opinions on guilt, opinions on the ultimate issue in the case. Because if you're saying Mr. Allen is faking, you're saying he's not credible. You're saying you don't believe him. You're saying he's lying. You know, this is a very, very fine line. So the state argued they are not testifying as experts on mental health or ultimate issues because, again, very narrow view according to the state. The ultimate issue is just the truth or falsity of whether Mr. Allen killed Abby and Libby. And so they're not, you know, by saying Mr. Allen is faking mental illness, they're not offering any opinion on whether he killed Abby and Libby. And it's not an opinion about the credibility of any witnesses. Well, I just don't see how you get around that it is. It is. he wants to elicit the observations and their opinion on if he's faking it or not based on their training as DOC guards, that it would be helpful to understand his behavior because, of course, Mr. Allen is putting his mental health at issue. And so, according to Mr. McClellan, this is going to be valuable information for the jury. He argues that these are skilled witnesses based on their training experience as guards and in that facility, that they have training in recognizing mental health symptoms, and they have observed witnesses suffering from mental health issues. So note the shift here. We've gone from very, very narrow readings of identification and opinions on credibility and so forth, to now a very, very broad definition of skill, right? Because what do they need to be skilled at to offer an opinion on if he's faking mental illness? They need expertise on faking mental illness, on what does that look like? How do you identify it? How do you tell it from true mental illness? But he doesn't say they have any type of expertise in that, just that, they work in a place where there's a lot of mentally ill people. That, according to Mr. McClellan, makes them experts. Well, not experts, skilled. Makes them skilled witnesses on the issue of faking mental illness. So he's saying it's got to be grounded in experience, knowledge, observations, past experiences, and so forth. They can testify as skilled witnesses based on experience that would give insight. They're not experts, so it doesn't violate that rule. They're not testifying on ultimate issues, the truth or falsity of the allegations or the truthfulness of the testimony. And it's probative because he brought his own mental health into play, and that the state will qualify each witness to be able to establish the foundation that they are skilled. So Mr. Rozzi, he got a little fired up in this part of his argument, and I don't blame him. He was a little bit angry. He said the reason why the state is calling these witnesses is because they want the jury to hear that Mr. Allen said something incriminating in front of them, and so asking if he's faking mental illness is asking for an opinion on his guilt, on is he sincere or is he not? And you can't separate those two. So whether he's faking or genuine when he made the statement can't be separated from the credibility of the statement that he's alleged to have made. He points out that the Department of Corrections has a whole team of mental health employees, including folks assigned to Mr. Allen, doctors, mental health workers. Any of them could come in and testify about this, but the state wants to use these experts, these non-experts, these inmates and guards instead. And Mr. McClellan just continued to deny that they're not talking about the truth of the statements. They're just talking about his behavior because they had him under observation 24/7. So Judge Gohl said they can clearly testify about their observations and about what he said. That is correct. Yes. Any witness can testify to their personal observations and what he said. So what he did, what he told them is on the table. They can't say if he's guilty or innocent. Yes. No, they can't. And they can't say if they think he's guilty or innocent. They also can't say if they think he's lying or not. She didn't mention that, but these are black letter rules of law. She said the state can lay a foundation about the perceptions of the defendant as a skilled witness, that will have to hear more from each witnesses as to their basis for their opinion on whether his behavior was genuine or not. So the door is clearly being left open for that to be able to come in. And if I'm the defense on that one, I am challenging that broad description of skill that the state is using here. Oh, because they've seen some mentally ill people, they can tell when you're faking. No, they have specialized instruments the psychologists use, the forensic psychologists use to specifically try to sort out malingering. Okay, malingering can be identified through these testing processes. Yeah. not a knee jerk, well, I think he's faking. Very, very troubled by the direction that's going. They moved on to the motion in limine about the iPass settlement. I don't remember what iPass stands for. Sorry about that, guys. But it was a lawsuit against the Department of Corrections. And so Ms. Diener argued this one as well. She argued that based on these motions, she argued that the iPass settlement had been used in the course of depositions, in questioning of witnesses, and so forth, and that it's not relevant because it's a separate lawsuit. It had been dismissed before Mr. Allen had ever been brought into the Department of Corrections custody, and so none of the witnesses that were being questioned were people who had any authority about whether DOC was going to follow the iPass settlement or not. And the relevant issue was the Department of Corrections policy, not the settlement, not the witnesses' participation in that, or lack of participation on it. The state alleged that this was merely to cast aspersions on the Department of Corrections, the fact that they were found to have violated the Eighth Amendment right of their detainees, the right to be free from cruel and unusual punishment, entered this settlement. And yeah, I mean, yeah, that makes them look bad. Sorry, sometimes the truth makes you look bad. So Razi said the relevance of the iPass settlement is that it had included a lengthy definition of serious mental illness, and that is what's central to the case, that inmates with serious mental illness are entitled to they have certain rights. They're entitled to certain forms of treatment, that Mr. Allen had a serious mental illness at the time he was brought into DOC custody in November of 2022, and therefore Department of Corrections is obligated to treat him in a certain way. So the current Department of Corrections policy is derived from the iPass settlement. It includes that same language, the definition. And so that's the main reason why they want it in. They want to educate the jury about how you're supposed to treat inmates, and in this case, a pretrial detainee in a solitary confinement setting. And so all of the issues about faking and so forth are relevant to his treatment at the Department of Corrections. He acknowledges there's other stuff in the settlement that relates to the specific plaintiffs in that case that's not relevant, fine with that being redacted, but that the Department of Correction officials have acknowledged the significance of the iPass settlement in formulating the current policy. His argument is that it helps to tell the whole story to use the iPass settlement, because the problem is it's a new policy, right? The settlement went into effect. I don't remember when it went into effect, but basically the case was dismissed in 2020. And so the policy, I think we can assume, was probably adopted, somewhere in that time frame, maybe give or take a year. I don't know. So it's still relatively new. And the concern is, I'm getting some foreshadowing here that we're going to hear evidence about mistreatment of Mr. Allen, or that it didn't comply with the terms of the policy that's in effect. And so his concern is that a Department of Corrections might try to excuse that by arguing, oh, well, it's a new policy, we're just getting used to it. Mistakes happen, it's unfortunate, but we do our best to correct them. Something like that. And so this then would tell the whole story that no, this isn't something that just popped up in a new DOC policy that they had to implement. It had been part of the settlement. It had been ongoing. The lawsuit arose, 12 years ago now. So this is not something new. It had been in process of being developed for quite a significant length of time. So basically just to rebut any kind of argument that, they should be excused because of the newness of the policy. So Ms. Diener argues that they're allowed to argue the policy. It already contains the definition. That's what was in place at the time that Mr. Allen was brought in. And so they don't object to any of that. So it was, okay, so Mr. Rossi, he filled in a little bit more of the background that the lawsuit itself dates back to 2012, but it was 2016 when the Eighth Amendment violation was found to have been committed. So then the settlement process, you know, was subsequent to that. So 8 years? 8 years? They've known that certain conduct towards prisons violates the Eighth Amendment. So they've been dealing with it for a long time. The judge ruled the settlement is not relevant to the issue at hand. It's inadmissible under many grounds. She doesn't specify what they are, but just it's inadmissible under many grounds. So she would allow him to get into the history of the issues in different ways, but not getting into the whole settlement, and is granting the motion in limine. So here's where we had a little bit of a moment. Mr. Rossi asked for clarification that is she only prohibiting the documents? And Judge Gold says, no, the motion references the lawsuit. And Mr. Rossi says, but the policy itself references iPass. So he's getting at, if they bring in the policy is going to reference iPass, therefore iPass is going to be mentioned in court. We have a little inconsistency in the ruling here that I can get into the policy, but I can't ever mention iPass. Judge says, but the issue that you're harping on is the definition of serious mental illness, and that's in the policy. You don't need the history of the policy. Now, most of the time when Judge Gold gets snippy with the defense, it's just in her tone. And this is something that a clever judge will know. Tone doesn't read through in a transcript. So, for example, there was a moment at one point where Mr. Rossi asked for clarification, and they had a discussion, and Mr. Rossi said thank you, and she's like, you're welcome. Just very, very snide, very disparaging. Just, you're welcome. You don't read that in the transcript. You're going to have to get the audio to pick up on the tone. And courts of appeal, reviewing courts, they get transcripts. They don't get the audio. So the overwhelming majority of this sniping at the defense is going to flow. It's going to fly under the radar at the appellate level because you can't read it on page. There's not like a notation, you know, said sarcastically or something like that. Would love to get a court reporter who would do things like that, but no, they're not allowed to. You're not allowed to editorialize the transcript. Well, this though was an instance where she slipped, and her words really let her disdain show, her contempt. She's got contempt for this defense team that she doesn't hide. This issue you're harping on. You mean the argument that they're making in the defense of their client and his rights and his treatment in the Department of Corrections and how that relates to his decompensation? And then the statements that he made that the state is trying to use as some of its primary evidence of his guilt? That issue? I sure as hell hope they're harping on that issue, because that's pretty central to the case. Very, very dismissive, very disrespectful, very discourteous. It's just not appropriate judicial temperament. This is stuff like this is a real discredit to the bench of the state. Hate to say it, but that's how it is. The motion in limine regarding Mr. Tobin. So Mr. Luttrell argued this one. This is the first time I had heard anything from him. So he argued the issue is not whether Mr. Tobin is an expert, it's what is his area of expertise and is it relevant and helpful, because he's a metallurgist. He's not a firearms expert. He's never been trained in or done the firearms analysis, the identification. He's never conducted research on firearms identification, but he acknowledged that Mr. Tobin has researched research on firearms identification. I'm not sure what that distinction means, but that was the distinction he made. So Mr. Tobin wants to opine on the methodology of firearms analysis, which, of course, according to the state, is very relevant and probative, and that Mr. Tobin's testimony isn't relevant because he's not saying whether the witness got it wrong or could have done a better exam. He would be testifying that she can't ever conduct a valid identification. And that's correct, because that's pretty much the state of the scientific consensus right now. The firearms analysis is not a science. It is not a science. So he relied on a case whose name I could not capture, but it dealt with a rape trauma expert. I found that interesting because in Washington, we also had some case law back in probably the 90s about rape trauma experts. This was something that would be used to bolster the testimony of somebody who was inconsistent in their statements, in their allegations on the stand. These experts would testify about rape trauma and what that means and what it looks like, and how, very common to have, confusion and memories come back later and things like that. And so therefore, then if somebody does these things, it means they're a rape victim. It means they have that trauma, they've survived. So it's this terrible implied opinions on evidence and stuff like that. So we litigated this in Washington, concluded this is not science, not valid. You cannot bring this into court. Apparently, Indiana went the other way. So they said that Mr. Tobin's issues aren't helpful. He can't testify to an issue about which he has no special knowledge, that he's testified mostly in Frye-Daubert hearings that go to the threshold issue of admissibility. So Frye and Daubert are two very common standards that are used to admit scientific evidence in courtrooms. They're named after cases that set those standards, described what they were. So Frye standard is generally what we follow in Washington, and it's is the discipline, is the science generally accepted in the relevant field. So they just defer to firearms experts to tell you if firearms analysis is valid. Yeah. Think that one over, and whether there's maybe a little problem with incentives in that type of framework. Daubert is the federal standard, and it is far more strict. It goes much more to whether the underlying methodology, the principles on which it's based, and so forth, are valid and reliable, and then whether it's those processes and principles have been appropriately executed in the case at hand. So many states, if there's like a novel scientific method that's being presented in court, it will have to clear this Frye or Daubert hurdle before it will be admissible in the first place. You'll bring a motion to exclude it under Frye, and then you have to have an evidentiary hearing where you call in the experts and they talk about whether it's generally acceptable or not, and so on and so forth. So because they didn't have a hearing like that in this case, because Judge Gold didn't grant a hearing like that in this case, they argue it's his expertise really just goes to admissibility. He advised us that there are two witnesses from the state and two witnesses from the defense on the issue of firearms identification. So apparently he is not the only one for the defense that is going to be testifying about this claim that the bullet came specifically from Mr. Allen's gun. So Mr. Rozzi testified, offered up Mr. Tobin's CV. He's an expert in metallurgy and material science engineering. He studies the properties of chemical and physical elements, how they combine and relate. It's a subdiscipline of tool mark identification, which firearms analysis is also a subset of tool mark identification. He had been the director of forensic metallurgy at the FBI for 27 years. He was in the lab dealing with tool mark identification. He has published in this area. He has testified 309 times in 46 states and has testified regarding firearms identification as a practice. He's contributed to decisions about the reliability of firearms analysis, cited specifically the Abrukwa case out of Maryland. This is, I've talked about this before. This was quite a revolutionary case because the Supreme Court of Maryland had extensive hearings on the reliability of the claim by a tool mark, a firearms examiner, that a specific bullet can be traced back to a specific gun, and concluded it's not valid. You can't make that claim. That is overstating the conclusion that you can reliably draw from these types of comparisons. You can conclude that they're consistent, but you can't say no other firearm in the universe could have possibly produced these markings. There isn't a scientific basis to be able to say that. So Mr. Rozzi pointed out that's, of course, the type of claim that the state is making here, that they'll say there's sufficient agreement in those markings to identify the gun. Remember, I mentioned that standard on Tuesday. That's their standard. That's their standard, not 7 points of comparison, not analyzing the electropherograms in the case of DNA. Sufficient agreement. And who decides whether the agreement is sufficient or insufficient? That examiner decides. There's nothing objective about this at all. So he points out the foundation of this discipline has been called into question. There's legitimate concerns about it, and he's been at the forefront of addressing some of those concerns. So the defense is also calling a Dr. Warren from Tennessee. Dr. Warren is different from Dr. Tobin, apparently, in that Dr. Warren is a member of AFTE, the Association of Firearm and Tool Mark Examiners. And so he is, I guess, more on the inside than the metallurgist under this standard that the state is setting. So they are both in accord on Mr. Tobin's analysis. They basically say the same thing as far as the critiques. And he pointed out that the argument is that since Mr. Tobin isn't in AFTE, that he's therefore not allowed to critique AFTE. That doesn't seem to make a lot of sense, does it? It's usually going to be outsiders that are going to be critical. And in fact, he went on and discussed the National Academy of the Sciences report from 2009 and the PCAST report. I forget exactly when that one was, but it was a few years later. These were scientists from all kinds of different disciplines, not specifically tool mark examiners or fingerprint examiners or bite mark analysts or anything like that. They are people drawn from a broad base of different scientific disciplines, and their purpose was to analyze the foundations of some of these forensic techniques and evaluate, are these reliable or not? And so many of them came under criticism, including firearm and tool mark analysis. From all the way back in 2009, the National Academy of Sciences has been saying, this isn't, you can't draw this conclusion. This is not scientific. You don't have You can't say what your probability is of a match. So you can't say to what degree of certainty, things that in ordinary, like real scientific processes that have an objective basis to them, you can establish those things mathematically. So it's like it's a replication problem. It's subjective. It's subjective. So obviously those are outsiders critiquing the science, and that's been, it's been pretty influential. It's caused a lot of downstream effects, like these types of challenges we're seeing here. So then Mr. Rozzi spent some time going through quite a bit of Mr. Warren's deposition, because he wanted to point out things like how Mr. Warren, Dr. Warren, I should say, had agreed that Mr. Tobin's credentials were helpful for firearms analysis and identification, that his background in statistics was important as they start to shift in the language that they should use in their testimony, and that he's been a big part of the ongoing movement to codify statistical approaches for the conclusions that firearms examiners are drawing, to make it much more like DNA, where you can assert, okay, this, probabilities of different types of comparisons. That the qualifications to be a firearms examiner, there's no accreditation, there's no minimum standard. So while they might like you to have a college degree in a hard science, it's not necessary. You can become a firearms examiner with a high school education. Know absolutely nothing about the underlying principles for it. This is a really critical point, because one of the counter arguments that's made to presenting an expert like this is, well, you can just cross-examine the state's expert, and you can draw it out through cross-examination. You don't need to bring in somebody to independently testify to everything. Well, you do, because the firearms examiners, they don't know any of this stuff. They're not familiar with the critiques. They don't understand, the statistical foundations and so forth. I will tell you a true story. I had a firearms examiner on the stand that I'm trying to cross-examine on some of these issues. And I asked the firearms examiner some question along the lines of, we're just getting at, like, what does a discipline, what kind of qualities does a discipline need to have to be scientific? And I asked about falsifiability. Does the result need to be falsifiable? And the examiner said, I don't know what that means. I don't know what that means. They didn't know that to be scientific, a result needs to be falsifiable. So that's the problem you run into with trying to cross-examine the firearms examiner. They don't know any of this stuff, so they can't tell you. They don't know what they don't know. So they can't tell you if they don't understand how statistics work and why that matters, and what, standard deviations are and so forth. They can't tell you. They can't give you the information that you need to be able to critique their discipline. They've just been trained in how to perform it. So Mr. Rozzi talked about how Mr. Tobin's critiques have helped to advance the discipline, and continues to help advance the discipline of firearms identification. He is always mentioned as one of the top groups of critics. Is it helpful to understand metallurgy principles? Yeah. Yes, according to Dr. Warren, metallurgy is a very helpful background for firearms identification. It's a hard science. They talked about, again, PCAST and the National Academy of the Sciences, like I mentioned, where according to those principles, firearms analysis is not a science. It's a discipline, meaning it's a practice. There's specified procedures and rules and standards and stuff, but it's not scientific because it's not grounded in those objective types of practices. So Mr. Tobin would explain that there is an underlying process that supports the discipline of firearms analysis. The problem is the analyst doesn't know how the process is established. She's just trained to do it. So she's the executor. Mr. Tobin is the theory guy. Is the theory irrelevant? I mean, the state will seem to think so. I think it would go to the weight of the conclusion that the firearms examiner is drawing. How serious should we take it? Well, that depends on how good a discipline it is, not how good of a job she did carrying it out. He pointed out that the guy who does the composites, that's also a discipline and not a science. And that's something that, of course, the law enforcement relies on extensively and, in fact, did in this case. So the issue is whether the conclusions that are drawn are reliable. That's to assist the jurors. It's a helpful information that Dr. Warren supports Dr. Tobin's conclusion and that it's relevant to understand the meaning of their final product. Melissa Oberg is going to get on the stand and just say, I've looked at thousands of these and this one is a match. And so it's only fair that the jurors understand the foundation that supports her making that type of claim. And so then he gave several analogies to situations where the underlying theory is relevant and admissible and kind of routinely admitted in court for that type of purpose. Certified chemical testing, your breath test. When you get pulled over for a DUI, the whole how that works, how the machine works. You pretty much always go in and explain that to the jury, and very common to bring in to explain, here's what some of these assumptions are that go into the calculation that the machine performs. To the eye of the police officer who's conducting the test, we're seeing a person blow into a tube, and then we sit and wait and we see a piece of paper come out of a machine. Like that's the level of knowledge of the executor. But the theory behind it, of course, is far more complicated. It has to do with, the ratio of alcohol and the blood-brain barrier and the volume of blood and the volume of blood, like just a lot of stuff and a lot of assumptions that go into that. So it's very common in a DUI trial to focus on that, especially if you have a test result that's like right near, 0.081. You're probably going to get in and have some testimony about here's the variables, here's the assumptions, and here's why those assumptions might not work in this particular case. We heard a little bit about that in the Karen Reed trial, if you watch that. So canine sniffs he used as an example. You get to hear, how do dogs' noses work? How are they trained? How does this whole process of being able to identify this but not that, how does that work? Polygraphs, radar guns, all situations that are pretty routine to look at the process so that you can understand if it's legitimate or not. And that tells you, can I rely on the results of this? I think polygraphs is a really good example because, generally not recognized as being legitimate because the underlying process is problematic. It's based on assumptions about reactions and why reactions to certain questions might occur and things like that. So he pointed out, he drew a distinction. The state had cited to a case from a different county in Illinois, not a precedential decision from the Court of Appeals, but a trial court ruling from earlier in the year where Mr. Tobin had been excluded. And it was a 5-line ruling that basically said, among other things, Mr. Tobin hadn't reviewed the evidence and the defendant could cross-examine the state's witness, and that would be adequate. That's what the state is wanting Judge Gull to do in this case. Mr. Rozzi offered a different trial court opinion from Illinois, from an Illinois court that was a multi-page opinion. I don't know exactly how long, but Mr. Rozzi was reading mostly from pages 35 and 36. And that particular court found that Mr. Tobin was credible, that the information was helpful to establishing that firearms identification is no longer generally accepted in the scientific community. And so he made an argument. I didn't like how he worded it. You know, sometimes we got to watch our mouths. It reminds me of that billboard, and you've probably seen that billboard meme for the defense lawyer. Just because you did it doesn't mean you're guilty. And this is the kind of thing lawyers love. Because, yeah, it's true. I mean, just because you did it doesn't mean you're guilty. You might not be guilty of that thing. They might not be able to prove you're guilty, you know, but it sounds really, really bad. What Mr. Rozzi said is that what's true isn't the point. What's true isn't the point. I don't know exactly what he meant by that, but what he was getting at was that the jury should be able to hear, as they are evaluating the most important piece of evidence in the case, that there is an ongoing debate around the entire country about the reliability of this kind of evidence. I really wanted him to say this goes to the weight of the evidence. He didn't say it. Those words didn't come out. I really wanted him to say it goes to the weight of the evidence, because the state's argument is that Mr. Tobin only testifies at Fry and at Daubert hearings. Those go to admissibility. This court has already ruled that it's going to be admissibility. That's part of his argument for why it should be kept out. But it goes to weight, not admissibility, how the jury should consider it and how much influence it should have in their decision. It's important information for that. So Mr. Luttrell responded that Abreuqua is an outlier decision, which it is, but it's also the newest one, and you know, trends start with one decision. That the majority of courts don't follow that, and they allow this testimony in. That is true. They do allow this testimony in, but they also allow the critical testimony in. So I don't know that that's a super helpful position, but whatever. He argued statistics aren't relevant. Statistics aren't relevant. They're not relevant. Okay. And that critiques have helped is a far cry from Mr. Tobin's views on firearms analysis. And the fact that there may be a healthy debate has nothing to do with the role of the jury. It has everything to do with what the jury is supposed to do with this information. So the judge took it under advisement, said very little on this one, just taking it under advisement, and she will issue a ruling in due course. In due course. Well, I am alarmed just because, from my perspective, the tendency so far from Judge Gull is that if the state asks for it, they get it, and if the defense asks for it, they don't. That seems to be almost squarely across the board. Few small exceptions, but not a whole lot. I don't see if Mr. Tobin can't come in, if she excludes him. I don't see how that's not reversible error. I really don't. I really don't. Of course, the jury is entitled to know if there's a problem with this discipline. Of course, they get to know that. It does not become irrelevant or unduly prejudicial or confusing just because it tends to undermine the state's theory of the case. The state doesn't get a default presumption that their evidence is correct and true and must be believed. The jury gets to not believe their evidence, and they're entitled to hear reasons why they shouldn't believe it. So I am concerned about this one. I think she has to let him testify legally. But as I just got done saying, I'm a little concerned about what seems to be an apparent lack of respect for the law by Judge Gohl. It doesn't seem to be a big driving consideration in her rulings. So we'll see. We'll see what we get on this one. So she asked then if there's anything else. Mr. McClelland raised the fact that there had been exhibit lists exchanged pursuant to a court order, that the defense also attached a witness list that included several that were not on a prior witness list. Some of them seemed to be experts. So he gave this timeline that on October 3rd, he asked Mr. Razi about new witnesses that appeared to be experts in digital evidence relating to cell phone extractions. Mr. Razi replied the next day to say it related to the data extractions from the phones. He delivered a thumb drive to the office the following week with exhibits and so forth. So Mr. McClelland tried to talk to the people. Their names are Neil Brune and Stacy Eldridge. Mr. Brune would not talk at all. He wouldn't answer any questions. He said his duty to the client prohibited him from doing that. That is correct. It is work product, so it is privileged. Ms. Eldridge said that she can't tell him what she would testify to because it's not established yet. So he said his concern is trial by surprise, that they don't have time to do depositions of these people, and they want some report or some summary from the experts or an opportunity to question them or something like that. Otherwise would object to those witnesses due to the late exposure. So Mr. Razi responded that the order that the court had given only required the exchange of exhibit lists. It didn't require witness lists, but as a courtesy, they went ahead and did that anyway. And also, as a courtesy, provided as many of the exhibits on a hard drive as they could get their hands on. And so, as far as the particular individuals that the state's concerned with, the state had done a new Celebrate phone dumps, and the state provided those to the defense in late August of this year. So that's what the defense was then submitting, was trying to get these folks on board to be able to review them and have an opinion about them and so forth. And that type of thing just naturally takes time. So he argued there's no bad faith with respect to untimeliness. That really cuts both ways. Had the state not disclosed this stuff late, the defense wouldn't be responding to it late, and we wouldn't have any of these issues. The names have been offered. They didn't ask to depose any of the witnesses. Mr. Razi said they were not opposed to some contact as a courtesy, but there are no reports. They don't exist. The judge then asked this, again, just very pointed question. So it's your position that you're not going to provide, these experts are going to testify, and you're not going to provide any report or any substance, any summary of the substance of their testimony. Is that correct? Well, Mr. Razi points out the rule doesn't require them to. And so I went and looked at the rule, and yeah, he's right. The rule says you got to turn over the report of an expert. If the expert doesn't produce a report, you don't have to turn it over. Indiana is very different from Washington in that they have this very liberal deposition process. You get to freely take the depositions of witnesses. And so it's a matter for discovery to find out what somebody is going to testify about in a trial. In my state, you have to get permission to do depositions of witnesses. They don't love it. So you typically have to make a showing of why you need it, why it's material, and why you can't adequately prepare without getting it, and so forth. So to me, that explains why the rule in Indiana is the way it is. You don't have to turn over, you don't have to provide a summary of the expert's testimony because they can depose the expert. You just have to tell them who the expert's going to be. If they have a report, you have to turn it over. But Judge Bev, I just called her that. Judge Gohl. Judge Gohl was, seeming to accept this implication that they have a duty to provide a summary of the testimony, and it seems clear from the rule that they don't. So Mr. Razi said they haven't generated reports. The rule, that's all the rule requires. There aren't any. Again, as a courtesy, he doesn't have a general problem. He doesn't have a problem with giving them the general gist of the testimony, but they don't have any obligation to give details. That's what discovery is for. McLellan said he's not asking for specifics. He just wants, all he knows is that they're going to testify about information contained in the phone extractions, and he wants to know a little bit more about the scope of what they're going to talk about. So they basically agreed at the end of the day that the state can talk to these witnesses, and the defense isn't going to have a problem with that. They asked for some logistical information about Department of Corrections transports of witnesses. The judge says that she's going to need a timeline. I don't know how the defense is supposed to present a timeline at this point, because it depends on the state. It depends on what the state does. If the state is going to say, I will be done at 5 o'clock on whatever date, okay, well then maybe you can do a timeline, but I guarantee you the state's not going to do that. They also asked for clarification, Ms. Auger did, on the order incorporating the previous materials from the evidentiary hearing on the third-party culprit stuff, to incorporate that as their proffer, as their offer of proof, for purposes, it's for purposes of appeal. But so they don't have to then call all of those witnesses back in at trial. The problem is that the order didn't say it included the evidence on the ritualistic killings, and asked if that could be incorporated as well. Mr. McLellan said, that's my fault. I wrote the order. I forgot to include that. And the judge said her intention was to grant the motion to incorporate all of it, so that they wouldn't have to take up that time at trial to do an extended offer of proof. And that was the conclusion of that. So let me get back to the jury, because again, I wasn't there to see the jury being sworn, but I did get filled in a little bit about what happened by Lawyer Lee and also by Bob and Ali Mata. And so it is 16. It is 16. It's 8 women and 4 men are the jurors, and then 2 women and 2 men are the alternates. So that is our breakdown in our composition there. One of the things that Bob mentioned is that the very last person who was selected, when we came back after lunch on Tuesday and we're like, why are we picking number 17? That person is on the jury. He's one of the jury members. And so what that indicates to me is that, yeah, for some reason that hasn't been explained on Tuesday, during the day, we lost a juror. Don't know why. Wasn't put on the record. They had an extended, I mean, I suppose they've had several sidebar conversations at this point. But yesterday or Tuesday during the jury selection, when they came back after lunch, they did have a fairly extended sidebar conversation. So I don't know if that's what they were addressing. Certainly possible. But at this point, we don't know what, why, who, how, anything like that. We just know that the last gentleman that was selected replaced one of the original jurors, not an alternate. So that's where we're at. And now we're getting ready for openings tomorrow. It's going to be a very, very early morning. And so I'm not going to be on too much longer. I don't know how much sleep I'm going to get tonight. Just being frank. Let me go ahead and go through some of your chats and comments. Sarita Banana is a YouTube member. Welcome, Sarita. Thanks so much for joining us. Chelsea, thank you so much for attending this trial and sharing your insights with us. Well, thank you for joining me. I'm very happy to be here. It's this wild. I gotta tell you, it's wild. I mean, this is like nothing I've ever seen. I've seen some crazy decisions. I've seen some bad judges. I haven't seen anything like this before. Okay, I was looking at jury rules in Indiana because of the comments regarding deliberations during the trial. Juries in Indiana can discuss the evidence during the trial. This is jury rule number 20A8. I can link. Okay, so that's fascinating. I'm going to write that down. I'm not going to have a chance to pull it up right now, but I will put it in my notes where I'm keeping little just things to follow up on. So jury rule 20A8. I'm going to check that out. Very unusual. They can discuss the evidence during trial. Well, I wonder, I mean, how is that distinct from deliberating? You know? If they can discuss the evidence, do we believe this? Do we not believe this? Is this good? Is this bad? It's strange. But thank you for pointing that out to me. I really appreciate it. I am definitely going to check that out. Kate became a YouTube member. Welcome, Kate. Glad to have you with us. Debbie W. If this argument about the sketches flies, what impact would that have about any other conviction or arrest that happened due to a sketch? This is really going to the admissibility of sketches in court. And so both of the parties indicated there's really not a lot of case law on this in Indiana. I don't know how often sketches end up in court. I've never had a case, a trial, where a sketch was involved, a sketch was used. Most of the time when crimes happen, they know, they know who it is. It's usually, usually somebody you know. So you're dealing with a limited subset of cases that are involving unidentified perpetrators. Unidentified perpetrators that then also includes this discipline of producing a sketch, more than just getting a description. Like I've seen lots of times where, okay, like somebody broke in the house and you see him, you see him on the porch. I can think of a case off the top of my head where that happened, and you'll get a physical description. Okay, it was a white male. He was probably in his 20s, slightly curly hair. He was wearing this color of a hat. Had a big nose. Things like that. Very common to get stuff like that. Far, far less common to actually produce a sketch to assist with an investigation. So I would think the opportunities for sketches to be used in court are in general going to be pretty minimal, and that's partly why there would not be a whole lot of case law about it. But it's not going to go to, at least I wouldn't think that it would go to an arrest. It wouldn't undermine an arrest because it's just, arrest can be based on hearsay. It's not, it's information that police have. And so it can be part of that investigative process and part of the reasoning for why, they think that the person that they've arrested is the person in the sketch. As far as admissibility in court, though, now this decision in and of itself is not going to be precedential. Whatever Judge Gold decides is not going to bind any other court. She doesn't have that much power, thank God. Appellate decisions are what are precedential and binding on trial courts. So let's say she excludes it. She says, no, you can't bring it in. These are not admissible. It's not relevant because it's just an investigative tool. So they can raise that on appeal. If Mr. Allen is convicted, that can be one of the issues that he raises on appeal. I should have been allowed to bring in these sketches because look at him. My client looks nothing like these. And that would have tended to prove that he was innocent. Say the Court of Appeals agrees with him. Yes, sketches are admissible. It was relevant to identification. Identification of Bridge Guy, and Mr. Allen is Bridge Guy, and therefore it was not hearsay. It's relevant to the issues in the case. It should have come in. So that's potentially a precedential decision. If there was somebody else who had not been allowed to bring in their sketch, then perhaps, they might have some avenue for an appeal or post-conviction relief based on this new decision. If the Court of Appeals said it's not admissible, you're not allowed to use it, it's hearsay, it's not relevant, then likewise in cases where somebody had been convicted and a sketch had been used to convict them, same thing. They may be able to rely on that that new case law to go in and seek relief. I've talked before on my channel about how post-conviction relief is just a minefield. There are so many procedural hurdles and the standards are extremely high, and so it's very, very difficult to do that. But one of the grounds that occasionally does exist for being able to reopen a conviction is a change in the law, subsequent change in the law that either is retroactive or you know, has effects like that. The problem is with things like admissibility of evidence, these aren't usually considered substantive law, they're considered procedural. And so typically changes in procedural rules, you're not going to get relief based on that. The fact that something was admissible 10 years ago that's not admissible today, if you were convicted 10 years ago, you're out of luck. That was the law at the time. Because these are not like constitutional principles, they're just court procedure. They don't get the same type of treatment as, like, for example, you get a new ruling that a certain activity violates the Constitution. Typically, you can go back, you know, to the beginning of time and argue. You know, if it violated the Constitution today, it also violated the Constitution 10 years ago when I was convicted. So it's probably not going to have any impact on other cases, but you know, you never say never in the law. Erica M., are skilled witnesses limited in the type or scope of opinion they can give, or are skilled and experts basically the same in Indiana? Well, this, from my perspective, is the million-dollar question. I can't really tell what the difference is. It seems to be saying that if you have some distinct knowledge or some distinct information that the average person doesn't have, and you can establish a foundation that you have that, that then you can you can give opinions that are related to that are based on that special knowledge. So if I'm trying to think of an example off the top of my head, I collect bonsai trees. Okay, so I know quite a bit about bonsai trees, how you collect them, how you pot them, the materials that you use, processes, things like that. And so, like, if we're in a trial setting and somebody has, you know, a small tree and we need to know, like, about the bone, you know, I might, under this skilled witness, you know, type of framework, maybe in that scenario, I might be able to say, you know, yeah, this looks like this is a highly refined bonsai tree. You know, it's probably been in development, or it's been in refinement for, you know, a significant length of time. Here's how I can tell, you know, something like that. I don't have any credentials or formal education or a degree, you know, in bonsai. I've just, you know, done it for a while and learned from people who've done it. And it's probably the kind of thing that most people don't know a whole lot about. So that's about the best I can come up with as far as that sort of distinction. I just still don't know that it gets them to expertise in faking mental illness. I think the problem is, again, they're trying to use this broad. There's lots of mentally ill people in prison. They even have special units for mentally ill people in prison. So you might have an opportunity to observe a lot of mentally ill people, but that doesn't mean that you have a lot of experience observing people faking, or being able to distinguish between people who are faking and people who are being genuine. I mean, like I said, there's a reason why psychologists have specific instruments that they use to gauge this. They don't just go in and off the cuff opine, you know. they might have a pretty good idea, because they'll be like, this guy is reporting things that are not consistent. This is quite common. Like, people, it happens a lot. People will try to fake mental illness, and they'll usually pretend to be schizophrenic. They pretend like they're hallucinating. They pretend like they're hearing things and stuff like that. But they do it in a way that is not reflective of how somebody who actually has schizophrenia will behave as a result of those things. So a psychologist is, probably going to have an idea, is going to get clued in from the report that, well, this might be faking. But they're going to use that instrument to get a verifiable opinion about it. So it's a fine line, honestly. As far as I can tell, in Indiana, it's like, if you have a degree or you have a certification or something like that, that makes you an expert. If you just have some type of, special knowledge, then you get to testify based on that. But it's a very gray area from my perspective. Chelsea, how do you think the jury will perceive Gull? Well, I'm interested to see how and if Judge Gull's demeanor changes in front of the seated jury. Jurors in general tend to really look up to the judge, like more than anybody else in the courtroom. The judge is the leader there in that courtroom. And judges often have a tendency to kind of suck up to the jury. The jurors are their public. In places where judges are elected, these are their constituents. So I don't want to assume that Judge Gull is going to, for example, continue to snipe at the defense in front of the jury, the way that she seems perfectly happy to do in front of the audience in open court, in front of the press. But we'll have to see. It can backfire. I mean, I have seen that happen, but they're going to give her the benefit of the doubt. And so that's really the concern, is if she's sniping at the defense in front of the jury, the question is the jury going to assume she must have a reason for doing that? Or is the jury going to wonder, is the jury going to be like, what's her problem? Not going to say it never happens that the jury is like, what's her problem? But I don't think it's that common. I really don't think it's that common. I think it's highly likely that the jury is going to look up to her and hold her in high regard. Sonam Lama. Couldn't you use the reconstruction artists as skilled witnesses interpreting identity of possible suspects? Well, they wouldn't have personal knowledge for the identification. They would be skilled witnesses with respect to putting in graphic form the verbal descriptions that a witness gives to them, right? I certainly can't do that. I can barely draw a stick figure, I could never produce a sketch, way beyond my skill set. On the other hand, my girl Heidi Elkington, who did my fish, go follow her on Instagram, Heidi Elkington Art. She would be able to do those. She would be able to do those sketches, no problem. She's gone with me to some of the hearings in Idaho in the Koberger case, and she's done some courtroom sketching there. So that is a skill, being able to interpret, just from my perspective, interpreting what you see into a drawing, then let alone interpreting what somebody is telling you into a drawing. That would certainly be a skill. It doesn't address the underlying problem of that witness's description is hearsay. It is hearsay unless we can get past it through that identification exception. And to the extent that they are identifying Bridge Guy, the suspect, it does seem to me to get past that. So, Excited Utterance. Did you happen to witness Gull refueling? Be safe, Andrea. Judge Gold was coughing a lot today on the bench. I've mentioned before, we have terrible, terrible acoustics in Fort Wayne in that courtroom. It's very large. Every little sound echoes, and there does seem to be a cough going around. Some of the bailiffs had it, somebody in the audience had it, and Judge Gold had it. So I certainly hope she refuels herself with like some airborne or something like that, you know, pop some zinc and megadose some vitamin C, stuff like that. I don't think a sick judge is more likely to be a cranky judge, in my view. So let's get her healthy. Tilly T, thank you, Andrea. Love from UK. Well, thank you, Tilly. It's my pleasure. Thank you for joining us. Appreciate having folks from all the way across the pond take an interest in this case and in these issues we talk about. Emily, hope you can do some lives with the Matas during trial. I do too. We actually, Bob and Allie Mata and Lawyer Lee and I all sat down and had lunch today. It was great. You know, it's always good to meet people face to face. Allie was like, oh my gosh, you're a giant. I'm kind of tall. I guess she didn't know I was kind of tall. You can't really tell when you sit here, you know, on the camera that I'm like 5'10". So yeah, sorry about that. But it was good to just kind of touch base and, you know, you check your perspective against the other professionals and kind of see, you know, where you're on the same page, where you're on different pages. Even just with basic things like, you know, what do you think about the strategy? What argument would you have made? Things like that. It's just, it's one of the fun parts about being a lawyer is being able to have those kinds of conversations with your colleagues. So I think we could have some great conversations like that. And I'd very much love it if we were able to do that. Chris A. gifted 5 Andrea Burkhart memberships. Thank you so much, Chris. And thank you on behalf of everybody who got one of those. So guys, legal pad count today was a short day. And like I said, I missed some. So I was only there for about a half day, but I did manage to fill. We're going to probably round it up to about another half legal pad. My pins held up today. I went through probably about half a pin. I'm going to keep using this pin tomorrow, but I'll bring some extra pins too. So where are we? Where does that bring us? That brings us, we're right about 2 full legal pads in the 3 days of trial so far. I do take a lot of notes, guys. That's why I'm probably not the person to follow if you want like a lot of courtroom observation. How are people reacting? What sorts of expressions are they making and stuff like that. For one thing, I don't like to try to read tea leaves like that. It's just, everybody thinks they can be a psychic with the jury. You can't be a psychic with the jury. You just don't know. You really don't. Had far too many reads that I thought I had, you know, that I was completely off base. Situations where, like, you know, the jury comes in, people have all these ideas like, oh, if the jury comes in and they won't make eye contact, it's because they're, you know, gonna convict. Or if the jury comes in and they're smiling, it's, you know, they're gonna acquit, or things like that. Like, no, there are no rules. The jury can be coming in smiling because they're so glad your guy is going to be in prison tomorrow. So I don't do a lot of observations, in part, you know, because I think a lot of times it's minimally helpful, but mainly because my head is down. I'm busy trying to catch the substance of everything that's happening. I'm trying to get my notes to reflect as thoroughly as I can what's going on in the court process. So not saying I'm not going to look if I get a chance, but just it's really not my focus in there. My focus is very much on these notes, so I can bring them back and share them with all of you guys. And so with that, I am going to prepare for a very, very early morning tomorrow. I don't quite know what to expect in terms of how many people are going to be there, what it's going to be like. I've seen that they have the gates erected now. The gates were not there when I got into town and went over to Delphi on Sunday just to kind of take a look around and, you know, get the lay of the land, so to speak. But the big blackout fences are now in place. The 2-hour parking in downtown is now in place. So we got to figure out where to park and hoof it over to the courthouse where we won't get towed or whatever. I'm expecting there's going to be a big crowd tomorrow because it's openings. I mean, openings are a really critical stage because we're going to hear what the evidence is going to show us. That's the purpose of an opening statement. Tell the jury this is what the evidence is going to show you. And so this is going to be our first look at exactly what the evidence is going to be. We know from the minis, according to the state, cases about bridge guy, bullet, and murder of 2 little girls. That's not an awful lot of evidence. Very eager to see if the state is going to give us more than that. Heard from the defense, their mini opening, brand new information about hair in Abby's hands, and the DNA does not match Mr. Allen. Very, very intriguing fact there. So what kinds of details we might hear from the defense? Who knows? Everybody wants to know, and that's why everybody is going to be at that courthouse tomorrow. But I am expecting that it'll likely fall off quite a bit after that, just because as you get into the details of the witnesses and so forth, a lot of reasons, people lose momentum, people lose interest, but also just the details aren't necessarily as interesting to most people that aren't following the case in super in depth. They're just not going to care that much about it. They want the takeaway. They want the big picture. So less likely to go to the hassle of getting to that courthouse and trying to wrestle their way into one of the public seats. Precocent, we just want the legal take. Oh, and the Rozzy. Well, I'm here for the legal take. I mean, that's what I got. That's what I got to bring to the table. So with that, guys, I am going to go ahead and shut it down, get myself to a very early bedtime, make sure my alarm is plugged in this morning, and my coffee machine is ready to go at dark 30. Got my fingers crossed, guys. Obviously can't make any promises, but I'm going to do my absolute best to get in there and be able to report back on those openings. So I will be back tomorrow, same time, hopefully, barring things out of my control, like the court schedule going super late or something like that. But my general plan is, if possible, I want to keep the stream at this 7 o'clock Eastern time, if that works, just so we have kind of a consistent thing that everybody can rely on and be prepared for. So that will be my plan for tomorrow, and I will let you know what transpires, if I'm able to get in, what I see, if I'm not able to get in, what I see, what I do, what happens, and so forth. So thank you again, everybody, for joining me. Thank you for your interest and for your support. It really means a lot to me to have so many of you tuning in day after day, all of your questions, all of your different opinions. I will have to point out that things are a little hectic right now. I mean, I know people expect that. It's just a little bit of a different level when you can't have access to electronics at all. Like, I'm very accustomed to just even when you're sitting in the courtroom and they're on recess or something uninteresting is happening, I will often use that opportunity to do things like go run down some of the law that applies, go look at some of the rules, look at some of the cases, things like that. We don't get that here. And that's before we even get to things like reading your comments, following up on notifications and questions and messages and stuff. A lot of people have reached out to me over the past week or so. And I do want to, I just want to make sure you know, I really do appreciate that. And if I'm not able to get back to people, it's just because I'm buried. I really am. I've always tried to, you know, pay attention. People tag me with questions and things like that, and do my best to answer them. I just don't know how feasible that's going to be in this particular situation. So it doesn't mean I don't appreciate it and I don't welcome it and value it. What I have seen in the comments and so forth, I see a lot of different opinions, and I value that as well. I appreciate that. I want to make it clear, if people disagree with me, that doesn't bother me at all. I appreciate you saying it, because I'm not the decider. I'm just one person with one opinion, and you know, you can take it for as much or as little value as you want. But there's lots of room for different opinions. And I'm one of those people that's of the view that there's no reason why people shouldn't be able to respectfully disagree with each other, and that actually makes us better. It makes us better thinkers, more critical thinkers, much more likely to get to the truth of a situation. So just because you disagree with me, don't feel like, you know, you shouldn't be here, or you need to shut up, or whatever. Now, please don't call me names, but, you know, I'll do the same. But respectful disagreement, that is something that lawyers live for. So feel free to keep that coming, and I do very much appreciate it. So with that, guys, we got one more new member here. Kraken Studio, the real booty, became a YouTube member. Welcome. Glad to have you. Thanks so much for joining us. And I will hope to see you tomorrow at 7 o'clock. I will let you know what happens and if I'm able to make it in for the openings. Keep your fingers crossed for me, guys. Thank you so much. I'll plan to see you tomorrow. Take care.